Rewriting the rules. Is it time to simplify fertility and embryo law? This discussion has been made possible thanks to the generous support of the British Fertility Society and Cooper Surgical. I'm Sarah Norcross, Director of PET, and I'll be chairing the discussion. I want to say from the outset that I'm also the chair of the British Fertility Society's Special Interest Group on Law, Policy and Ethics. And rewriting the rules is something that group had been thinking about for some time now. Now, during the course of this event, I'm not going to say Human Fertilisation and Embryology Act every time. I'll either say the HFE Act or just the Act. So we have Professor Alison Murdoch, Dr. Ippokratis Sarris, Professor Emily Jackson and Stuart Lavery. Alison is President of the British Fertility Society. She is Professor of Reproductive Medicine at Newcastle University, and she is the former head of Newcastle Fertility Centre. Alison has led the work looking at the Act for the British Fertility Society's Special Interest Group on Law, Policy and Ethics.
So the role of the HFEA is determined by the requirements of the legislation, and much of that legislation relates to the intentions of Parliament in 1990. So the questions we have to really ask now is, are the intentions then still appropriate in 2022? And if not, then the legislation should clearly be revised. Before we start, I think it's important to define the terms of the title that I've been given. By professional, I'm not considering just the narrow scope of my own clinical profession. A professional is someone who has got skills and knowledge in a specific area. And there are very many professional organisations, thus the scope of the title is really very wide. In relation to guidelines, there's a spectrum. On the left here, it would include clinical practices that take account of the varying needs of patients. There's been a long debate about whether medicine is actually an art or a science, and in practice, I think it's an art based on a science. It needs to take account of patients' needs, so guidelines have to have some flexibility, and therefore they're usually presented in a should format. And then at the other end of the spectrum on the right, there are the guidelines and standards that relate more to clinic management, and those are things against which a clinic would be regulated. They are fixed. So, for instance, a regulator might require to know all the collections that have been reported. So then the clinic would be required to keep a register procedure, and that instruction would then be a must. So the guidelines on the extreme left are the ones that you would expect from, say, a professional society, learned society, whereas those on the right, being fixed and measurable, are more consistent with standards that are devised for regulatory purposes. The HFEA Code of Practice, in its introduction, it calls itself a rule book for clinics. And since a rule is a must instruction, this rather assumes that the guidelines that are produced by the HFEA are over on the right of the spectrum. I'll come back to this later with a few more detailed examples. But I think, first of all, it's probably important to understand all the guidelines and standards that infertilities are subject to. This is a very extensive list, and I can't discuss them all in detail. Generally on the left, those are the ones that are the guidelines produced by learned societies, where those on the right are the standards produced by regulators. I've placed the HFEA slightly separate from these lists because in practice, the HFEA produces guidelines both similar to those that are from learned societies, as well as standards against which they carry out inspections. And this whole regulatory field is a minefield for clinics. And at a time when the intention is to remove regulatory burden, I think this must be taken into account when the HFEA Act, when the Act is reviewed. I think if politicians and society are concerned that a practice within the fertility sector is unacceptable, then that almost implies that all these other organisations are not performing acceptably. So giving more power to the HFEA is perhaps not the logical solution. So let's just have a look at some very specific sections of the Act as illustrations. First of all, Section 8 requires that the authority must carry out its functions effectively, efficiently, and economically. That means that we must not only know the intended outcome, we should make sure that what they do produces the intended outcome. There must be maximum productivity with minimal waste, and there must be a prudent use of resources. It's important to make sure that if these requirements relate, I'll discuss them in relation in terms of other examples of the Act and the role that is prescribed for the HFEA. But if the Act makes requirements that do not allow the authority to be effective, then and makes the authority ineffective and inefficient and uneconomical, they must be removed. So then the general functions of society include a requirement that they should keep under review information about embryos and any subsequent development of the embryos, and about provision of treatment services, and the authority must provide, to such an extent as it considers appropriate, advice and information to persons to whom the license applies or receiving treatment. Now, this is a very non-specific requirement that actually gives the authority unlimited scope. Furthermore, it now does not recognise the requirements of GDPR under the Data Protection Act. All information that's collected and held must be justified. Now, although the authority really should take this into account as it implements the Act at the present time, this is actually not what happens. If this requirements under Section 8 of this Act are meant to remain, then consideration really should be given to making specify the requirements to be consistent with the Data Protection Act. The Act then should be amended to state that the justifications for why the authority should collect information are clearly stated. The Act also empowers the authority to give advice. Data the HFEA collects should obviously be appropriately available to clinics and to patients, but this is different from giving advice. Giving advice requires interpretation and understanding of the individual needs of the recipient. We have, by legislation, a large lay authority, and that really cannot be responsible for giving advice to this very specific requirement. So I think that requirement should be taken out of the legislation. The Code of Practice, it requires that there's a condition of your license to which this subsection applies, is that any information related to the quality and safety of gametes or embryos shall be recorded and provided to the authority on request. This is very non-specific, and this causes the problem. So whilst an embryologist might agree that, for instance, losing an embryo would be relevant to safety to pass that information on to the authority, such an event would actually be reported as an adverse event under other sections of the legislation. Quality is very much more difficult to define. The science underpinning pre-implantation embryo development is really still uncertain and being investigated. So theoretically, a study that could, for example, retrospectively investigate the external laboratory temperature compared to blastid development rate would actually provide information that might relate to the quality of embryos. So under the legislation, that should be reported to the authority. Now, this is neither appropriate nor consistent with how scientific investigation is managed in the other field. In fact, it's a barrier to innovation, and therefore this requirement really should be taken out of the legislation. So now we come to a fairly major section, which is that the authority shall maintain a code of practice, giving advice about the proper conduct of activities. Effectively, this describes the guidelines produced by professional organisations. It means that we see in the code of practice, therefore, repetition of the guidelines and the standards that are produced elsewhere. So this is inefficient. It's uneconomical because the authority has to then keep it under review. Furthermore, it's also potentially ineffective as it conflicts with other guidelines and standards. So, for example, Schedule 2 of the Act repeats the details of the quality management system in detail, but these are also described by professional organisations in quality management, such as ISO. The Code of Practice also gives details about standards required for giving sedation during an egg collection procedure, but this repeats and references guidelines provided by the Royal College of Anaesthetists. So this is really ineffective. The authority also is required to give guidance about what is suitable. The term suitable implies that the activity is fit for purpose, but this also requires an understanding of the clinical context. It's an unacceptably wide brief that gives the responsibility to authority. As I said before, it consists of esteemed members, but they are mainly lay members. In practice, the authority relies on the Scientific Advisory and Standards Committee, and that gives them advice about what they would consider to be suitable. SCAC looks at evidence such as published trial data, reviews from Cochrane, clinical practice guidelines that are provided by, for instance, professional societies, ARCS and BFS and NICE. This information, though, is already available to clinics, so it's inefficient for it to have to be repeated by the authority. Indeed, the code of practice is actually sometimes unhelpful. For instance, here is an example from the code of practice. An RFID reader system is used to track gametes and embryos through the laboratory and is a valuable tool to help embryologists in their work, and also to confirm that the embryo relates to the correct patient, so it helps for patient security. But the code of practice states that although there's evidence for the use of RFID in medical setting, as far as the HFEA is concerned, no independent studies have yet been done on the effect of electromagnetic radiation on human gametes and embryos. So there is not yet compelling evidence base to enable the HFEA to consider that the RFID reader system is risk-free. Now, it's quite difficult to see how this relates to their requirement to assess what is proper or suitable. It raises doubts without mentioning the benefits. It's unhelpful for clinics who will actually be using a medical device that's been approved by the MRHA. And for a patient who might read this without understanding the full details, it might cause unnecessary anxiety. So for these reasons, if we're reviewing the Act, I think consideration should be taken that the requirements in legislation for the authority to determine what is proper and suitable should be removed and given to the professional societies. So let's look at another example. Embryo testing. In relation, the legislation states that embryo testing is permitted if there's a significant risk that a person with an abnormality will have or develop serious physical or mental disability, serious illness, or other serious medical conditions. And then it gives the role to the authority to determine whether a specific test fulfills this criteria. So in practice, testing is only permitted if that condition is on the authority's approved list. It may be relevant to consider implementation of this legislation in comparison with the implementation of the Abortion Act. And I rather hesitate to do this, but I think it's relevant. In that legislation, there is similar flexibility in the conditions for which abortion is legal. In practice, the decision about whether or not conditions of the legislation are fulfilled is made during the consultation between the clinician and the patient, and that reflects the reproductive choices of the patient. Professional guidelines and support is available, but there is no third party who intervenes in that decision. The clinician will remain accountable for their action, may be subject to prosecution if there's subsequent objection by a third party. In relation to embryo testing, the need for there to be a third party intervening in a clinical decision, therefore, needs to be reviewed, and justification for this requirement is required before it should remain in legislation. There's another role for the authority, and that's the role to specify information that must be given to patients. Primary legislation specifies that information must be given to the patients included in this case, and the importance of informing any resultant child at an early age that that child results in the gametes of the person who is not the parent of the child. Now, I would agree that this advice is now consistent with professional guidelines. We must question, though, whether it's appropriate for it to be prescribed in primary legislation. In 1990, Parliament and society considered secrecy and confidentiality were critical and actually enforced this in the Act. But then when the academic studies showed that this was not ideal, legislation needed to be revised. This was inefficient and inflexible. Professional guidelines can evolve based on academic study and society's views. If statements like this are placed in primary legislation, it meant that the authority had no choice but to implement them in licence conditions. This inflexibility has the potential to cause change that might actually to prevent change that might benefit patient care, so should actually be removed. So I've only given here a few examples to illustrate how the prescription of the role of the authority in the Act in the setting of professional relative to the setting of professional guidelines is problematic. It's recommended that if and when the Act is reviewed, all the sections need to be reviewed to ensure that the role of the authority in relation to professional standards and guidelines is specific, that it's justified, that doesn't repeat and duplicate professional guidelines and standards that are given elsewhere, and that the role of the authority is consistent with the expertise in the competition of the society.
Next this evening, we have Dr. Ippokratis Sarris. He is Director of King's Fertility and Consultant in Reproductive Medicine.
I think I, first of all, have to declare my conflict of interest, which you pretty much already heard. I'm a consultant in reproductive medicine. I'm a director of a large clinic in London. And I think those are relevant, of course, how I see and view things. I'm also the HFA person responsible for King's Fertility. And again, I have a slightly different way potentially of looking at things. But most importantly, I'm the member of the BFS Executive Committee and a member of the Law, Policy and Ethics Special Interest Group. I think what's important is to first of all look at our stakeholders. We've got this data from the HFEAs, and actually it's our patients. And that's the most important thing that we have to keep in mind. And also we can see that, of course, the majority of our patients are in sort of straightforward, IVF and heterosexual couples, but of course we have other scenarios as well, which we cater for. And of course, as we heard before, IVF over the years and ART in general has become more and more prevalent. Now we have over 50,000 patients a year having an IVF cycle, and actually just under 3% of all babies in the UK, about 2.7 last time I checked, were born through ART. So this is not experimental. Again, I echo what Professor Murdoch said. This is everyday practice. And again, it is time to look at it like that as well. Now, we talked about the law, but what is relevant is not just the HFEA Act, but it's also the European Commission and the European laws that have been transcribed into the Act. And again, that was a topic that I was talking about here at PET a few months ago when it came down to screening of same-sex female partners. But on top of that, we have an entire sort of gamut of other acts as well, which is relevant. And we have to understand that a lot of these things are covered elsewhere, but also can be contradictory. Now, we've heard about a regulator, the HFEA, and again, we shouldn't forget all the other regulators, as Professor Murdoch mentioned, and then we've got our learning societies and our royal colleges, and of course, funding, which is slightly different, but a lot of the stuff that we heard about, especially what Sarah mentioned, what expectations are about funding, comes into this discussion as well. So, of course, no wonder the confusion with so many things, so many regulators, so many legislation going about. Now, what I'm going to talk about now is consent specifically, and the three levels which are relevant to the Act is, of course, the consent to treatment in itself, but it's also the information and the counselling and how that comes into the consent according to the Act and the authority, and of course, consent to parenthood. Now, I'm not going to go into parenthood in detail because, of course, we've got the expert, Emily, who's talking about it afterwards, Professor Jackson, so I'm not going to talk about it just apart from the consent bits of it. Now, the aim of the consent really is to document the agreement for the medical or surgical aspects of what we're going to do. And these principles are similar to all medical treatments, doesn't matter if it's IVF or if it is a heart transplant or is it removing a mole. And these have been documented quite extensively throughout many other organizations like the CQC and the General Medical Council and the BMA and so on and so forth. So there's nothing new there really. But we also have to keep in mind that fertility treatment does have some specific differences which are relevant to what we do. It by and large involves two patients, and even if it's a single person, there is somebody on the other side that provided one gamete. and the consent also must be compatible. Of course, we potentially talk about long-term storage of gametes and or embryos, and hopefully there'll be a child born after the treatment, and there can be legal parenthood issues which must be clear. Now, interestingly, the HFA Act does not distinguish between consent to medical treatment and consent to parental responsibility, and it's something we're going to talk about in a moment. Now, if we look at how the HFA Act falls short in this particular area, well, it repeats legislation elsewhere. We've heard that very nicely from Professor Murdoch, and one could argue that only what is relevant from a consent point of view with relation to gametes or embryos or parenthood should be in the actual HFA Act and not repeat practice elsewhere. And this duplication can also be seen when it comes down to the actual consent forms. They are HFEA, so now authority-specific forms, but in addition to them, there are a number of center-specific treatment consent forms, and these effectively duplicate the same sort of thing. And if we look at current practice, what happens, although the law requires that specific consent forms are provided, it's not really specific with regards to the drafting of this form, and the HFA has over 50 separate consent forms that must be completed to comply with the license conditions. And one has to be fair here to say that when they were first introduced, the consent forms were less well organized, and potentially license centers required some help and guidance. But nowadays, centers have very robust and extensive in-house consent treatments, which actually are specific to their patients, their practices, and maybe local variations as well. So it's difficult to see some of the basic HFA forms, how much more they add to what already quite extensively are covered elsewhere. And since the Act was introduced, there been very little change in these forms as well. And this is something interesting. I have to admit, I didn't come up with it. I'm not that clever, actually, but it was pointed out to me. I thought I'm going to bring it to you, that actually the HFA forms do not directly reflect the legislation. So the Act relates to the use of embryos, and the HFA forms relates to the creation of embryos. But actually what we do is a consent to mixing eggs and sperm, because we don't know if an embryo will come out of it, or let alone we'll be able to use it. And I think this sort of highlights a bit sort of the issue with how the Act and the forms and everything is written, because effectively we're talking slightly different things, although we all think we're talking about the same thing. Now, also what happens in current practice, you have the parents or the patients filling the forms, and they don't always necessarily agree with what they put in, and then clinics have to go back and sort of make sure that they match. And we have to be honest with this, that most clinic staff just see the HFA form as another form to complete that you have to do it for regulatory requirements. There's some things which are actually completely relevant, and we talk about consent to research in the forms, but actually you can't really do research just with that form. You need specific consents and forms and information about the specific research project you have in mind. So it's completely almost obsolete. And there are so many forms, so confusing. The fact that they create so many problems that they lead to legal challenges just is an illustration that the process is not correct. And it's not so much the HFEA consent, but it's the over-complex HFA Act and the legislation that then has to be catered for through the authorities as well. Now, if we move down to the next level of consenting and information and counseling, what is interesting is that within the Act itself, it talks about the offer of counseling to those that are receiving licensed treatment. But specifically, it refers to independent, confidential therapeutic counseling by trained counselors. And actually, this is not related to the consent process. So the problem with the word counseling is that it is confusing. So in both the HFA Act and the Code of Practice, it talks about information counseling, and this is an integral part of the consent process, but the counseling reference in the Act itself relates to the social consequences, basically the implications of a child, an existing child, or a future child. However, it's interchangeably used, the term implications counseling in the Code of Practice in relation to consent as part of what is the expected practice of consent taking by the clinical team. And then if we go back to the Code of Practice and the Act, it talks about opportunity to receive proper counseling about the implications of treatment. And again, it talks about a qualified fertility counselor with confidential documentation. And again, this is a therapeutic process, which is independent of the treatment process, and thus is separate from consent. And of course, although it is an integral part of all medical care to give this opportunity is not part of the consent process. So there's a lack of distinction between these forms of counseling, and this causes recurrent regulator problems, recurrent sort of discussions. And I think it's all in the wording, not that we disagree that all forms of this counseling are important. So if we look down to the information, well, the HFA Act requires the HFA to decide what information to be given prior to consent. And again, we heard this from the talk from Professor Murdoch before. But then this becomes overly prescriptive. And effectively, it means that the information to be given to patient is directed by the regulator and is not patient determined. That's not in keeping with the principle of good medical practice. And of course, it can't keep up as the evidence evolves and the particular needs of the patient when it is written within the regulatory framework to be able to give specific type of information. And if we go one step further, we look at parenthood. Of course, I'm not going to go into detail. As I said, we're going to have an excellent talk later on from Professor Jackson. But what is relevant, I just want to point to one thing, is the provisions of the parentage provisions in the Act apply mainly, and what is relevant is when donated sperm is used in treatment. And it also states, and this is very crucial actually, that a consent for the legal parenting from the second parent must be given before the treatment. It doesn't specifically talk what forms have to be used and who's responsible for it, but those are two very important time points. Now, again, if we look at what the issues are, well, effectively, legal parenthood is a highly complex field of law. It relates to family law, and there's a separate act of parliament about that. And we have to be honest that clinics, although have a responsibility to inform couples who are unmarried or not a civil partnership on the implication of legal parenthood, they're actually medical establishments. They provide clinical treatments. Clinics do not have the expertise to give complex legal parenthood advice. And again, a lot of the problems arise because of the HFA consent forms, which are currently used to determine parenthood and the completion process. And the fact that there's so many errors and so many issues that then lawyers have to get involved to be able to disentangle means that the process is not working. If you have so many issues, there's something wrong with the process. And again, it's true to say that most of the times it's straightforward, but a lot of the times it's not. And there's a number of now quite well-known cases that had to go to court to be able to look at various issues that happened with the consenting process. So if we just go back to some recommendations through what was pretty much a whistle-top tour of issues about consent, I think it's important that there must be a clear distinction between the consent for the medical treatment, and that is and can be regulated elsewhere, the consent which relates to the actual storage or use of gametes and embryos, which should remain within the HFA Act, and one could look at the consent to the potential parental responsibility and where that should lie. This is of course open to debate and how that can be worked out in practice. But also the use of multiple separate consent forms is a source of conflict and confusion. One could argue that maybe it could be that if you're having treatment with somebody as a couple, then there should be a single form that is signed by both. As a consequence, you can have matching sort of preferences, and that will result in less error. And again, I have to go back to this confusion about therapeutic and support counseling and information provision, which is part of routine consenting process. And it is appropriate for both the legislation and the regulator to make a clear distinction and to reconsider potential terminology of counseling and how it's used in the Act in relation to taking consent. And again, we heard this from Professor Murdoch. You know, the provision of information, may that be written or oral, is an integral part of consent process, no question about it. However, one can argue if it should be in the Act and the regulation to include this over-prescriptive list of information that needs to be given, and if it should be amended. And again, I agree, and I think we agree to agree here, of course, is that this should be deferred to the professional bodies, and it's a matter of good clinical practice. It's not for primary legislation. And finally, when we talk about responsibility for legal parenting provisions, again, where that should sit is open to debate, the different opinions about it. But currently, the code of practice requires clinics to give information about legal parenting, and that's fine in the majority of cases. But it also says that it's the clinic that has to be satisfied by any information that the parents have, the prospective parents have provided, and any legal advice they have. That's actually written within the provisions of lack of consent, for example, and the issues there. And I really believe that this is outside of a clinic's expertise, and that only should not be on the clinic itself. And it's possible that instead of requiring an additional legal parent form to be completed, the fact that somebody is consenting to treatment, it's a clear intent in relation to the parenthood intent. And as long as they're being completed in time and appropriately, and there's information within it, possibly there's no need to have another set of forms, which then gives you a layer where mistakes can happen, and then you kind of have to end up in court. And the final thing I'll say is that the use of seamless use of stored embryos and gametes, new forms have come out, and it's really, this must be simplified. It's become a lot of bureaucratic. It's actually created a lot of issues with clinics since the 1st of July when the new forms came out, which I think were all done very, very good, sort of with good intent, but clearly this creates a lot of sort of problems for understanding of the patients of what they need to do. Just from a straightforward IVF cycle, so I'm not even talking about parenthood forms and donation, stuff like that. And the patients need to read and complete 42 pages of HFA consent forms, and we have another 44 pages of either in-house consent and information that we give in order to be able to prove to our inspectors that we comply within all the information that we have. That means a total of 86 pages of information for patients to read, understand, and sign. And you know, if that's not too much, then what is?
Our next speaker this evening is Professor Emily Jackson, and Emily is Professor of Law at the London School of Economics and Political Science, and she is a former Deputy Chair of the Human Fertilisation and Embryology Authority. Emily is author of several books, including Medical Law, Text, Cases and Materials, another one called Law and Regulation of Medicines, and finally, probably most apt, Regulating Reproduction, Law, Technology and Autonomy.
So most children who are born using IVF are conceived with their parents' gametes, and so parentage is unproblematic. The issues arise, as Ippo's already suggested, where donor gametes are used. And the parentage provisions in the Human Fertilisation and Embryology Act are one of the most complex and confusing aspects of the statute, not least because actually there are two sets of rules. The 1990 Act sets out the parentage of children born between 1991 and 2009, and the 2008 Act sets out the rules of parentage which apply to children born after 2009, because the peculiarity of the 2008 Act, in most respects, it just amended the 1990 Act and then dropped away as an amending piece of legislation, but it's there as a freestanding piece of legislation for parentage rules. So already it's confusing because we've got actually two sets of rules. Now I'm not going to, I'm sure you'll be glad to hear, I'm not going to go through the rules in detail because they are spectacularly confusing and complicated. But for anybody who isn't familiar with quite how confusing this looks, I just thought it might be helpful to set out the various different scenarios that the legislation provides for. So first of all, there's one set of rules if the mother is married to or in a civil partnership with a man. In those cases, there's a presumption of fatherhood unless he didn't consent to her treatment. The next set of rules applies to women who are not married but would like a man to be the father of their child. Then he can become the father with the agreement of both the mother and the father. So that's known as the agreed fatherhood conditions. As I say, I'm not going to go into it in detail. I'm just trying to set out quite what a confusing jumble of provisions it is. Next, we have rules that apply if the woman is married or in a civil partnership with a woman. Again, there's a presumption of parenthood unless the other woman didn't consent to the mother's treatment. So it mirrors the rules that apply to married and civilly partnered opposite sex couples. And then there's another set of rules that apply to women who are in relationship with a woman, but not a civil partner or marriage. So somebody wants a woman to be the second parent of the child, and then again, she will be the second parent if you have the consent of both the mother and this second woman. So really, really confusing. And as Ippo said, one consequence of these fantastically complex rules is that there are inevitably a set of different forms that people have to fill in depending on which scenario they fit in. The more forms you have, the greater the likelihood of human error in filling them in, or in administrating them. So that has led, again, as Ippo indicated, to a series, dozens of cases in which judges have had to resolve uncertain parenthood and make declarations of parenthood to remedy errors in the completion of the forms. So while this is just an example, there are many, many more of this, cases like this. So while courts can sort this out, if a form hasn't been filled in and somebody is unexpectedly not the parent of their child in the way they thought they would be, so it can be resolved. But this is obviously hugely stressful for parents who get a call out of the blue to say there's been a problem with the paperwork, and as a result, they may not be the parent of their child. So although there is a mechanism that the courts can use to sort out these mistakes are obviously incredibly upsetting for families. So not ideal. So the other thing that Ippo also mentioned, but I think is really important here, is the use of the word consent in relation to the agreed fatherhood and the agreed parenthood provisions. Because consent to parenthood is taken at the same time as informed consent to medical treatment. And this is really confusing for patients who are being asked to consent to multiple things, to storage, to treatment, to posthumous use, and to being a parent. These are very, very different things. Agreeing to be the parent of a child is not the same thing as consenting to medical treatment. And I think the fact that the Act kind of elides them by using the word consent here, this is from the agreed fatherhood and agreed parenthood provisions, the word consent is used. I think that makes this confusing for patients who are unsure what they're being asked to do at various points. This isn't consent to treatment. This is agreement to be a parent, and they're slightly different things. So all in all, it's unnecessarily complicated, and I think it's also outdated. So these different rules that apply depending on whether the woman receiving treatment is married or is civilly partnered with a man, unmarried and wants a man to be her child's father, married or in a civil partnership with a woman, or unmarried and wants a woman to be her child's second parent. The reason for this difference between the married, civilly partnered mother and the unmarried mother is that these rules reproduce the presumption of legitimacy within marriage, which obviously in 2022 strikes us as really outdated, having a set of rules which are basically based around the idea of legitimacy within marriage. So they're outdated, they're overly complicated. The other problem with the rules as they are is I think they're in a couple of respects out of step with the way in which families describe themselves and families see their relationships. So one oddity in relation to the rules, and this has been the subject of a recent case in the Court of Appeal in the UK, is the definition of mother is the person who gives birth. And that means that if a trans man is able to give birth because he hasn't had his reproductive organs removed as part of gender reassignment, if a man gives birth, and there have been cases where this has happened, including the McConnell case, the law insists that he is registered on his child's birth certificate as the child's mother. It's not open to him to be the child's father, and it's not open to him to just be the child's parent. So that if a child who grows up in a family with a man who gave birth, he's not going to call that man his mother, that's going to be his dad. But the law insists that legally that's a mother. So that's one way in which the rules are out of step with how families see themselves. Second way, I think, is that while if the mother has a male partner, in law, he becomes the child's father from birth. If the woman has a female partner, she's not the child's mother. Legally, she is parent to. And that's the case even if she's the child's genetic mother, if it's a case of shared motherhood, where one female partner carries an embryo created using the egg of another. So even if the non-gestational member of the couple is the child's genetic mother, she is still legally just the second legal parent. She can't be the second legal mother. So, of course, families aren't going to describe her as parent to. So again, the rules are a bit out of step with how families describe themselves. So I think a plea here in any reform of the Act would be for simplification. I think the key issue that should define whether or not somebody is a child's parent is whether they intend to be the child's legal parent. I think the law would be better if it used intention to be a parent as the criterion here, rather than the word consent, which gets it all muddled up with consent to the medical treatment. I think it also might be worth considering whether or not it would be helpful to use gender neutral language here, which would simplify things further, and we could talk about gestational and non-gestational parents. I think, as Ippo said, it might also be sensible to take some of these rules out of the Human Fertilisation and Embryology Act and reform family law provisions relating to parentage and birth registration in the round. We know that there's going to be some draft surrogacy legislation, for example, soon coming out of the Law Commission's report, and that will obviously have something to say about parentage provisions as well. So there are wider parentage issues than the ones that are in the 2008 Act. But that's a bigger project. Big reform of parentage may be a bit ambitious for what is going to be feasible in any imminent reform project. But in the short term, I do think there are things we can do. I think you could simplify the parentage rules, both to make them more comprehensible and a better fit with family life. And I think that would be better for parents, I think it would be better for children, and I think it would be better for clinics.
So our final speaker this evening is Stuart Lavery. And Stuart is the Divisional Clinical Director of Women's Health at University College London Hospitals. And Stuart is a consultant gynecologist and specialist in reproductive medicine and surgery.
I want to look at 32 years of the person responsible and to try and ask the question, is it time for a change? Having been a person responsible for 15 of those 32 years, I'm hopeful that I can provide a little bit of experience and evidence around this role, which is not limited to being a clinician. So I want to start off by really looking at three issues. How did we get here? If we don't change, what are the challenges that the status quo leaves us with for the current role for the PR? And then finally, to finish off with what I hope will be the most interesting piece, what should the future look like if we grasp this opportunity and look to change? So at the moment, the HFEA Code of Practice actually states that there is no more important role than that of the person responsible for the successful running of a UK fertility clinic. There are statutory requirements that come under the Act for the PR and the role of the PR. And then there's a whole set of responsibilities for the PR that are dictated by the Code of Practice. So there is no doubt that the current status quo leads us with very significant expectations on the person in the clinic as an individual. So I know how this feels. And I think anybody who's been a PR will be aware of the enormous responsibility and accountability that currently comes with that job. And really what I want to consider is whether those expectations of the regulator, could they be unrealistic? Look at some of the things that that individual person is expected to do. You have ultimate responsibility for all licensed activities. There is serious consequences if you're not able to perform your role. You're responsible for the paperwork, the fees, and the data submission. You have to be inspection ready at all times, looking after incident reporting, compliance, safeguarding, and health and safety, everybody's favorite topic. Ultimately, you're the one who takes responsibility when things go wrong. Is it realistic to honestly expect a single person in an organization to fulfill all of these roles in 2022? Even more so, there is no deputy allowed, and there is no delegation of responsibilities allowed. And if you do not fulfill your requirements under the Act, you may face a criminal liability. And there is case law where a person responsible has been taken to court under criminal charges for the actions of an embryologist in their clinic. There is no other branch of medicine in the United Kingdom where all of these tasks and responsibilities lie with one person. In fact, I think if you went around reproductive services around the world, you would not find similar responsibility placed on the shoulders of one person. So let's ask ourselves, is a parliamentary act that is 30 years old, is it fit for purpose to regulate a field that's changed beyond all recognition? And I think the central part of the argument is that fertility service and IVF is now a normalized part of medical treatment. And I think it's time for that reality to be reflected in how the service is regulated. Because everybody, I believe, wants change. I think the regulator, the legislatures, the sector providers, and I think the public understands that all these years later, for a normalized medical treatment, we need a different set of rules and a different set of guidance. So what are these challenges if we don't change? Well, the code of practice has been able to evolve over time, but it's far more difficult for a legislative act of parliament to evolve, given the speed and the rate of change of technology, ethics, and public opinion that we see in our sector. So my belief is to echo the thoughts of the previous speakers and ask for simplification, which I think many people would actually describe as the ultimate sophistication. Because if we simplify the law, it's going to stand us in much better stead as we move forward. My concern is that the regulators' main, that they've expressed, their main worry is that they don't have enough sanctions available. And although sanctions may be an important part of the Act, I don't believe that they should be the priority. Not only do we need to look at the role of the person responsible, but we need to look at the framework between the relationship of the license holder and the person responsible. There is confusion around this. Anybody who's worked in an IVF service will understand the role of the multiple disciplines within the fertility sector. And I think that the assumption for the responsibility of all of those roles within a clinic should lie with one person. I think it actually diminishes the leadership, accountability, and the credibility of partners in the multidisciplinary field. And again, a criminal level of liability for the person responsible is inconsistent with other medical practices. And as the regulator themselves find out, is incredibly difficult to actually enforce. Clinic ownership has changed. This act was designed for a world where the clinics were smaller and it was very easy to understand who owned, managed, and led the clinics. That's no longer the case. 60% of IVF provision is in the private sector, and much of private sector provision is now through private equity-backed consolidated chains of clinics. In fact, these are now the major providers of fertility services in the United Kingdom. We need to move away from an individual responsibility to more of a corporate responsibility. And in fact, this problem is not limited to the private sector. Those of us who work in the NHS understand the challenges within the NHS of decision-making, funding, and governance. And I would submit that in the private sector and in the NHS sector, to have the role of the person responsible vested in a single person is unrealistic. This role is too big for a single person, bottom line. So where should we go? What can we do? What could happen over the next year or two? Are we even going to get this act before Parliament to consider? And how can we guide and influence the path? And I'm reminded of Niels Bohr's comment about predicting the future is particularly challenging. But what do I think we should consider? What are the nuts and bolts and the fundamentals of consideration for change? I think that number one, we need to remove the criminal liability around the act and reflect that this is now a normalized medical practice, and that the normal governance for medical roles should take place here. We should even consider being bold and actually removing certain things from the act, because we need the act to be simple so that it can adapt and change as our field adapts and changes. It's more realistic to consider a form of corporate responsibility for running these complex services, not with an individual. And indeed, to reflect these changes, I would be in favor of actually the regulator and the law dropping the title of person responsible. Because even if we reform the role, if we keep the same title, it's very likely that similar ethos may carry through for it. And I'd be more inclined to look at titles such as registered manager, which is what the CQC use, or even chief regulatory officer, for which larger organizations tend to use. I also think the Act needs to carefully consider dropping the suitability test. I think this is old-fashioned, dare I say, I think it's paternalistic, and it's incredibly difficult to objectively document and quantify. I am sympathetic to the regulator when it says it wants to look at more sanctions, because if the only thing it could do is put the person responsible in court or remove a license, then clearly there are much more minor infractions that they may wish to sanction. And so I think it's not unreasonable for the regulator to consider that. But the most important, I think, is engagement. This is an opportunity. It's an opportunity that only comes along once in every 15 years or so. And I think the regulator, the sector, patients, everybody with a stake, and boy, are there a lot of stakeholders in this field. I think we all need to engage, to participate, and to really value the democratic opportunity that we have here. So I want to finish with this quote from a UCLH colleague, Charles Darwin, who said, "It's not the strongest of the species that survive, nor the most intelligent of the species that survive. It's the one that is most adaptable to change. We have an opportunity for change. Let's seize it." The person responsible is chosen and appointed by the license holder for the clinic. Now, so you can't be a license holder and a person responsible. It has to sit in two places. The license holder, who therefore is in charge of deciding who the PR is, can be an individual or an organization. So, for example, it can be a board within an NHS organization or a management board within a private consolidated clinic. So it's the license holder. Now, of course, the next question is who chooses the license holder? And that's a far more opaque question veiled in the mists of history. Usually the owner of the clinic in a private sector would be the license holder, would have the ability to appoint the PR.
Gosh, it's just making it sound like the Masons or something. You have to do some sort of, secret thing. Okay, so thanks for clearing that up, Stuart. I think you also talked about, this sort of suitability criteria. Could you just explain a little bit more about what that suitability is, and if Alison or Ippokratis want to chip in on that, then please do.
Yeah, so the answer is I'm not sure what that suitability is, because I think it's a very difficult thing to define, and it's an incredibly difficult thing to quantify. So I think that's the reason I would drop it, is because it's hard to define and hard to measure.
Alison or Ippokratis, do you want to add anything?
I've not got much to add to that, except that it goes with many of the other things as mentioned in the Act that are just vague and uncertain. And therefore it causes problems not only for clinics, but it also causes problems for the HFEA, because then they have to define what they think is suitable, and what does that mean? How do they do that?
Let's,
I mean, what I would add is, you can have some very simple, if you really need to have metrics, how many years experience, have a relevant degree in a field, blah, 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 the exam, whatever it is. I think the principle is I agree with what Stuart said, is just obsolete, is paternalistic. I think the wording itself is inappropriate, let anything else. Beyond that, you can come up with metrics. I think it's not so much who is suitable, as do you really need a law to define that somebody is suitable? And then just leave it vague as that, let alone everything else, which I agree, of course, 100%. Being a PR myself, I know all the pain.
Can I just add that in terms of where we are now compared to 1990, remember in 1990 there were no professional society of embryologists. There was no college training for reproductive medicine. So we're in a completely different field. Now you're not likely to be leading in a fertility clinic unless you have got some specialist training in reproductive medicine from the college. If you're going to be a senior embryologist in the clinic, you're going to be approved through their training programs and accreditation programs as well. So we're in a different field completely from where we were when the role of the PR was first decided.
Okay, so I'm going to move on to the next question, which is from Jane Stuart. Jane says she agrees with the relevance of HFEA forms overly complicated, and now we have a second legal never event potential as the result of the routine inclusion of posthumous use for women without the ability to state consent for the use in surrogacy in the same form. Moreover, to allow for this, therapeutic counselling is mandated, as well as genetic and infection screening. The fallout of making this an effective opt-out rather than a separate conversation in rare relevant cases means has added a layer of complexity and cost. And this is something I've heard quite a few times from different people in the sector. Ippokratis, I can see you nodding. Do you want to come in on that first?
Yeah, and I have slight investments. I know the cases that went through. Let's put it that way. So I know why the HFPA has done this because, of course, the issue, as a lot of us will know, was that there was no process before. So, of course, it fell through. And now there's a process, which means now the onus is on us as the clinics to make sure we follow that process, which is great. But the problem is it's led to huge confusion with patients. Effectively, every single patient just ticks the box. And then we explain, and we have a new information leaflet, part of that 86 things that we give with the other 15-page consent form to explain what it means to consent to surrogacy and what you need to do, and all the stuff that, of course, Jane mentioned. And most of the time when you go through that, they say no, but it invariably adds another 15, 20, 30 minutes of a discussion and being incredibly confusing. Now, if it's right, if it's wrong, I think for me, the main problem is not if you're going to use it for surrogacy or not after posthumous use, it's the screening. Forget everything else. That is something which is a huge burden. And then again, let's not even talk about costs. And of course, if you really want to screen, you have to come back for something which is an incredibly rare event. And I think, sad as those events are, incredibly, there's no question that I do know of the cases, not quite well. And there's no question it's absolutely terrible. These are so rare. And I called it a little bit, it just like almost like a knee-jerk reaction. I'm not really sure. And I don't know if the answer is primary legislation, because if legislation is, and we've all agreed as professional societies that surrogacy requires to be screened as a donor, forget everything else. That is always going to be a barrier. So I really, honestly, I think that it's got a lot of problems, but I can't see really a solution out of it. I'm very interested to know if anybody else has a solution, a practical solution, let alone just a tick box exercise of how we can actually offer this as an opportunity to patients, but at the same time get around the fact that it's incredibly rare. It takes a lot of workup to be able to be ready for surrogacy, screening and everything. So I really am a little bit stuck on that one. I just know that it created more problems after that consent form came through for the 99.99999% of patients that will never need it.
Does anybody else want to come in on with an additional comment to that?
I'd just say I think the process of giving consent is so complicated and confusing for patients. The more we can do to simplify it and make it clear what they're being told and what they're being asked to consent to, the better. I think having unnecessarily confusing forms which allow you to consent to posthumous use of embryos if you're a woman, but without specifying that that would have to be through surrogacy, seems to me to be unnecessarily confusing for patients.
What are speakers' thoughts on how hard it is for data on assisted conception to be used to link with later health outcomes? At present, the HFEA Act, as I understand it, prohibits release of such data by clinics to other health bodies. This inhibits, for example, the publication of statistics on early miscarriage that do not present elsewhere in the health system, and complicates research on consequences of assisted conception in pregnancy and for children's later health. So who wants to tackle this one first? Alison?
Yeah, I'm happy to have a go at it. I mean, I think there's two issues here. The first is due to consent, because the law at the moment requires patients to give specific consent to disclosure. And if they do not consent to disclosure, then that means that the HFEA cannot release their information to anybody else effectively. This is one of the things in the Act that we haven't mentioned in our talk today, but it's another thing that we really do feel needs to be removed, because it is not good, as the questionnaire is suggesting, for research, but also from patient care, because we need to be able to share information about care with their other healthcare providers for them as well. The issue specifically about miscarriages is actually raises an issue that I did mention, which is about information, because the HFEA does actually collect information about miscarriages. So if there is a pregnancy resulting from assisted conception treatment, the outcome needs to be notified to the HFEA. So the question then comes back to why that information is not more readily available. It should be perfectly possible to provide anonymously that data from the HFEA database. If the Act said not just that the HFEA should collect information and advise, but specify the reasons that it should be made available, collected, and the reasons it should be made available, then it would be required for the authority to provide that information in a format that anyone could read. There are lots of other situations where the government collects information and then publishes it anonymously. And it could be done. Whether you then move to the next stage, which is how you would link data from the HFEA, say identifying the children born from IVF with adult cancer rates, is another issue. But technology now is available to do it. And if there is legislation that impedes that, then that is bad legislation in 2022 and should be revised.
I can see nods from the other panelists. Does anyone want to come in? Is everyone in agreement there? Stuart?
I think it's a huge missed opportunity, and I think the Scandinavians have put us to shame, and they provided such an enormous amount of helpful data to providers and to patients by the ability to look at long-term outcome, by linking the registries of fertility treatment to the registries of cancer, like Alison has just described. And we need to start removing these obstacles to good research that the regulation has placed in front of us.
Ippo?
Yeah, I mean, I'll take it one step further. I think it's not just the HFEA, but it's also with the GDPR. I mean, now when people and you ask for the GP, you have the right to have your NHS records, obviously not to be used for research. One of the fears, obviously, is that people are going to be selling it to companies and the rest. There's legitimate fears about it. But one thing that we've noticed here, we had to contend with and some of my colleagues, not just in fertility but outside, is that you can't just use anonymously, records to look at whatever. And I think the issue is the two layers here. I think the first one is the HFEA Act, the fact that there is this sort of kind of wall, which I think is just in itself just obsolete nowadays, that we have different sets of notes and everything, and they have to be harmonized. I think that's the first thing that we can do, and well, no, we can't do, but we can propose if there's a change of the Act. We can't do anything, of course, Parliament does it. But beyond that, I think there's a wider issue about use of information and medical information. And I think over the last few years, things have got worse with regards to that. I think that's a bigger decision about society, and if that data should be used for public good or not, or individuals have the right to block the use of it. Again, we're talking about anonymous data. So I think it's two questions and it goes beyond. So even if this was fixed, I think we've still got an issue in the UK with regards to be able to use medical data, and it's getting worse and worse from that point of view throughout healthcare.
The law regarding single women receiving donor embryos is not clear, thereby disadvantaging them to be treated using donor embryos.
The parenthood of the male, the sperm provider that created that embryo is not clear. And there is a risk that under those circumstances, the man who was not originally identified as a donor could end up being the legal parent of that child. And that needs to be, that's an anomaly that needs to be corrected when Emily gets her wish and the legislation is changed.
And actually the anomaly continues because that links with the fact, and actually I had a number of patients this becomes an issue, where if you have treatment as a couple, and then you mutually decouple, as is the term I guess nowadays, but still amicably, the male now sperm provider of that embryo was happy for the now single woman to use her embryo, which they had together before, and for him to be a donor. And the law does not allow that. You can only be a donor at the beginning. And if you've ever used the embryo for your own treatment, you can't then become a donor. So it actually happens not just about single women using embryo that's been donated from partner treatment, because it's different if it was donor sperm with the donor egg, that's fine, because the intent was always for that person to be the donor, in which case it doesn't matter what their status is, married or not. But it's when they had treatment as the intent to be themselves, that may be and then they donated it, or actually with a partner and they're not together, they can't be a donor retrospectively, which I find this is again coming back to modern times and societies. I think that's something that has to change. It can't be that you can only be a donor at the beginning and then you can't just say, well, we're not together anymore, but I'm happy for you to be a donor, but I don't want to be any legal parents. And I've had a number of cases, surprisingly actually a lot after COVID, we didn't have any before, but quite a few that came through from relationships that broke down. And that's how those two are linked. And I think that is effectively is one stone, two birds with one stone, if that is sort of sorted. Because again, I don't know, Emily, if you can clarify if I'm right or wrong, but that's my understanding of it.
It's really complicated. These situations are really difficult. But yeah, the rules just need to be made much clearer so that people are really clear about what's possible, what's not possible, and I think simplification would be really helpful.
It would seem to me as well a real pity if this isn't resolved, so that donor embryos are quite a rare resource for use in treatment for other couples, and I think it would be really unfortunate if it isn't resolved, so that if people want them to be used to help someone else create a family, that they can't be used. The next question is from Helen Clark, and this is for Emily. How can we lawfully treat shared motherhood couples? We must screen the egg provider as a donor, incurring extra cost and delaying treatment whilst quarantining embryos, yet we mustn't and don't want to discriminate against anyone in a same-sex relationship. So I'm going to go to Emily first. I know that Ippo is going to want to come in on this because it's something he's actually spoken at a pet event about. So Emily, if you go first.
This is a real oddity in the rules, which comes out of the EU Tissues and Cells Directive, which was incorporated into UK law, and which makes really oddly a specification about a donation between partners, but it assumes it's a man and a woman, which means that there has to be this legally this extra screening where a woman is being treated with an egg created with her partner's egg, and it's ridiculous. And I think everybody realizes it's ridiculous, and it needs to be changed. I mean, I think the issue you raise is a really, really important one, and I think there's a potential Equality Act challenge here, because it's treating somebody less favorably than somebody else on the basis of their sexual orientation, which is a protected characteristic. So I think there probably is the appetite to change this, and it really does need to be changed.
Why does the Act Code of Practice say that those who provide eggs in shared motherhood by IVF or in gestational surrogacy arrangements have to be treated, screened as donor in both situations? It's not reflected of what's actually intended. So relates to your point, Emily, about determining parenthood by intention only.
I think it's the same answer, in fact, as the last one, that it's an oddity that needs to be sorted out, the treating women in shared motherhood arrangements in this way. I don't think there's anyone decided to sit down and draw rules that would discriminate in this way. It's the result of some rather ancient rules that apply in this way and treat women differently. And as I said before, I do think this will be changed. And it's important that it is, because it isn't fair and it's discriminatory.
The reason why we have this issue is because of the European directive that was incorporated in the UK law, and it was the definition of what a partner is. And that's where the crux of it. So in European law, the partner, and why, I mean, I put my understanding of it now, I think why, a partner is a man and a woman. It was very clear about it. While it's not the UK Act. So one of the problem is, of course, that was incorporated, but now we've had Brexit. And you know, it's an opportunity to diverge. And I think actually one frames it that way and says, actually, it's a UK issue, which we were lumbered because of a European act. If anything, there's a competitive advantage, regardless of what you think about it or not. And and I think that was really the crux of it. It was a European directive that came. It was not a UK law that effectively made it, you know, so discriminatory.
What are the speaker's thoughts on the transfer of mosaic embryos? I think the Act is silent on this, meaning that it's left at individual clinics, leading to considerable variability in the transfer of mosaic embryos. So I suppose this is, it sort of then leads on to another question about what the panel think about the legislation actually saying anything about specific medical things.
Thank God that the Act doesn't have a view on this, because it's a great example of why the Act must not have specific technological or scientific pieces of law. You know, if we'd have asked this question of the sector 5 or 6 years ago, I think we were terrified about mosaicism, and I think the vast majority of clinics would not have transferred mosaic embryos, to the ultimate detriment of the patients. Science has now advanced, and actually the data is absolutely solid on this, about the safety of transferring mosaic embryos and the fact that they lead to healthy, normal babies. So this is exactly the sort of issue that we don't want in any parliamentary legislative act, because it will actually lead to the detriment of patient care. So I think this is another vote really for simplification within an act.
I think Stuart's probably said it all in that answer. So if no one's got anything to add, I will move on. So someone asks, should the area of responsibility, I think they're talking about the role of the person responsible here, be broken up to make them more manageable? So perhaps legal, clinical and research. What do people think about that idea of actually sort of separating the areas of responsibility, having perhaps 3 roles? Holy Trinity at a clinic, I don't know.
Yeah, so I think it's important for us to get the right message across to the lawmakers and the regulators, in that clinics are not trying to abdicate responsibility and accountability. Clinics are perfectly happy to have that responsibility and accountability upheld. We just don't want it in one person. And I think we need to explore different models about how that can be delivered. It's the depersonalization of the responsibility that I think is important.
Anybody else want to comment on that one? No. Okay. So the next one is for Emily. So it says, if, as the previous speaker suggested, that 90.7% of couples seeking IVF are heterosexual couples, then gender-neutral language isn't representative of reality. I'm not quite sure what the question is in there for you, but why do you think that considering gender-neutral language might be important when revising the Act?
I mean, I think one possibility is that mother and father is obviously binary, there's just two. Parent, there could be potentially more than two, and many children do have more than two people who are in a parental relationship with them. So if a female same-sex couple have a friend who is going to be father of the child and going to have a father-child relationship with them, that child, I suppose, has two mothers and one father. But if the law were to just call everybody parents, then there wouldn't be the need to say who's the mother and who's the father, and we've got to identify just one, because you could have more than one. I mean, I'm not suggesting that this is something that will necessarily happen, but I think it's worth contemplating, because I think there could be advantages. So the McConnell case is a really good example of that. That the use of the word mother there is really odd, I think, and out of step with how the family will see itself. And similarly, the difference between men whose partners are treated with donated sperm and women whose partners are treated with donated sperm, where one can be a father and one has to be a parent too. It seems to me that you would iron out some of those oddities by saying, well, we just have parents. The law does distinguish in, this is a kind of family law issue rather than a Human Fertilization and Embryology Act issue, between gestational and non-gestational parents. And that's because if people reproduce naturally just through, it could be in a very long-term committed relationship, it could be a one-night stand, it could be rape. And so the law draws a distinction between the parent who gives birth, who automatically has parental responsibility, and the non-gestational parent who will have, usually of course the father in those scenarios, who will have parental responsibility if they're on the birth certificate. So it's possible for you to have a non-gestational parent who doesn't have parental responsibility. So that's the reason for drawing that distinction. But that's kind of not really an issue in these cases. I think the reason for thinking about gender neutral language in these cases is more to iron out some of these oddities of the way in which the law describes families.
Thanks, Emily. And so there's a follow-on question. It sort of follows on from this. Again, it's for you. So someone says, as Emily said, the genetic mother is called parent 2 in shared motherhood IVF. I believe this is not the case in surrogacy. When the intended mother uses her own egg, she becomes the mother upon receipt of the parental order, I think. It seems odd that a woman whose spouse carried their child is not the mother, but a woman whose child may have been carried by a stranger is. Well, first of all, has the person asking the question got that accurately? And then two, yeah, what do you think about it?
Yeah, I mean, I think obviously the rules on surrogacy are also confusing and complicated and unnecessarily so. So I do think all of this needs to be looked at. There are some real oddities here, also in relation to if you were to be on the issue of the trans man having to be a mother if he's treated with donor sperm. If the trans man has the baby through surrogacy, he can be a parent that way. He doesn't have to be a mother or a father. So there are some real, I mean, I think the bottom line is this is hugely confusing, hugely counterintuitive in lots of ways, and anything this confusing when it's this important about who a parent is obviously undesirable and makes life really difficult for clinics, as well as being unnecessarily complicated for patients.
Yes. So I think that is, sort of epitomizes some of the problems here, doesn't it, really, that, there are these contradictions, and it's not, as you said, it's counterintuitive, and you have to think each time, about quite how it's going to work. I also find myself having to do almost like a little diagram of working out who's who in some of these cases and where things and how these things flow around, and that is it's not ideal, is it, really? I think then there must be a simpler way of resolving these things. So we have Rachel Bowlby's question next. So she asked, regestational, non-gestational parenthood as a possible new neutral definition. Is one difficulty today that the situation is no longer necessarily binary to biological parents, one of each of two biological sexes. Instead, there can be two biological mothers, the one who's pregnant or one who provided the egg, either may be the intended mother or both, or neither for that matter, but in effect, three, not two biological parents, and giving birth no longer the fixed reference to defining parenthood and maternity. So sorry, that's quite complex. Emily, do you want to sort of comment on that first?
I think that goes to the point that I made earlier, which is that the reason for distinguishing between gestational and non-gestational parents is not really an HFE related issue. It's this kind of wider issue about parentage and the acquisition of parental responsibility, which is slight. I mean, as I say, the whole law here could do with an overhaul. But the question is absolutely right. That I think one of the things that is really peculiar, and again out of step with how people see themselves, is if you have two women who are both biological parents, one's gestational, one's genetic, that for them it's really, really strange that the law doesn't recognise both of their motherhood. So I do think we do have and one of the other issues here that I think is really key is the fact that the rules don't fit with how people understand their family relationships.
Thanks, Emily. So there's a question now from Lucy Scott, which I think might go to Alison first, as she's from Newcastle. Is there a policy around the creation of embryos from three individuals, i.e. mitochondrial donation? How would parentage be assigned in such a situation?
Yeah, well, there was a debate about this when the issues related to mitochondria went to Parliament. The donor of the mitochondria is not considered in the same way as a gamete donor, an egg donor, because they're not contributing any of their nuclear genetic material to the resulting embryo. So a mitochondrial donor will never be a parent. Yes,
so they're not an identity release donor in the same way that an egg donor would be. Or a sperm donor would be, for that matter. Okay, thanks for clearing that up. So there's another political question for you. So is the current UK government's penchant for increasing economic growth by removing regulation helpful in potentially simplifying the law in such a complex area? Well, I can see nods and shakes of the heads and sort of broad grins. So Stuart, we'll go with you first, then Ippo. I think they're a bit more keen to answer this political question.
I think it's very unlikely that simplifying the law around assisted conception is likely to lead to any economic growth. This is more about improving the welfare of patients. And I think that's it.
Ippo?
I sort of slightly disagree with that one, just for have to be the controversial. I think anything that increases the regulatory burden increases the cost of the clinic. I need to increase my time that my nurses speak to patients. That means more people, more power, resources. Forget the printing or whatever. We don't print anymore. We're electronic and so on and so forth. That is cost. That is cost that has to be passed on, obviously, further down. Now, if you can decrease cost, and regulatory burden is a cost, forget, the license fee and all that kind of stuff. I'm talking about actual sort of amount of work that it takes to just fill these things. And also the amount of auditing to look at the forms, because that's what it's about. And if you have it right, what happens with that? That is real cost. And if you can then make IVF cheaper, talking about that, because you can remove cost, then it's more likely, one, people can afford it, and then they can have the families that they all dream of. But also that then increases, that's the whole point of a growth of an economy, is you have a bigger economic cycle because you can do more with less cost per. And I think, so I know this is a bit sort of far-fetched, and I'm not saying that I agree with the government and everything they're doing, but I do think that, yes, you can get growth by decreasing to some logical and simplifying and sophisticating. I like that word, that sort of line, Stuart. I might steal it from you. Sophistication of it, rather than, and I think that can actually have an impact further down. So no, I think it can, for those reasons.
Does anybody else want to come in? Oh yes. So we'll go to Alison and then Emily.
Well, it's interesting that the the government policy for increasing economic growth hasn't recognised that part of the problem is the lack of the workforce in the UK. So if we had simplified IVF provision, we might have more provision of more babies for the country. Therefore, we might have a bigger workforce, and that might, in the long run, increase economic growth in the UK. But the only real way to do that is to increase the provision of IVF on the NHS so that there's more services being provided, and we haven't addressed that issue. Interestingly, that was a suggestion from the original Warnock report that it ought to be provided on the NHS. We seem to have missed that, and we seem to have too much concentration on regulating what goes on in the private medical care sector.
And Emily?
Well, I was just going to say previous governments have tried to go down the route of the bonfire of the quangos as a way of removing red tape, and there's been suggestions over many years that everybody here will be, everyone on the panel will be really familiar with, about merging the HFEA with the HTA, and I would just say I really, really hope that this government doesn't try to do something similar, because that a huge amount of time and energy and expense was wasted on all of that. And I think the key thing is to get the legislation simpler.
One almost feels we must be due another bonfire, or whatever they call it this time, review of the arm's length bodies, because it's a policy that seems to come round every sort of 5 years or so, and it's been a while now since they suggested it merge with the CQC at a time when the CQC was failing. So Ippo, do you want to come back in?
Yeah, I just want to say that, it's because that is the easy thing to do, and it's exactly what we're having this discussion. You want to save some money, let's cut some bodies and merge things together. But that's not where real growth comes. The real growth comes from the legislation, the difficult bit, simplifying what you have to do, have the same regulators. No one said we shouldn't have a regulator, just exactly what Emily said, and make things streamlined and easier, and overall that will have growth. So I think the problem is with that sort of bonfire is because it's almost the easy thing that's cut to head count. That's not the problem though overall, and that's a very short-sighted way of looking at the problem. This is the problem that we're talking about.